Okay. Thank you everyone for joining us for today's session. We have Marie Newhouse joining us from the University of Surrey. Marie Newhouse is a senior lecturer in law, philosophy, and public policy at the University of Surrey. Her research focuses on legal philosophy, especially Kantian accounts of legal obligation, the nature and limits of the state's legislative authority, criminal wrongdoing, and legal interpretation. Current projects use Hohfeldian legal concepts to clarify aspects of Kant's theory of innate right, recharacterize the necessity defense as a domain of residual liberty, and explore metaethical questions related to the nature of justice. Today we are going to discuss Marie's paper titled Innate Right in Hohfeldian Terms, Part 1, Legal Obligation, Criminal Wrongdoing, and Necessity. Thank you very much for joining us, and we will start with Mary. You have the floor. Thank you.
Thank you to Angelica and Xavier and Trenton for having me today, and to all of you for taking an interest in my paper. It is the latest in a series of related papers that I've been attempting to work out a Kantian framework for ascertaining the legal obligations that we have in presumptively legitimate states, such as those that many of us reside in. Questions about revolution or the minimum legitimacy conditions of the state are of interest to me, but apparently not quite so interesting as the more mundane questions that we face every day here in the UK about what our legal obligations are. In fact, when I started writing in the Kantian paradigm over 10 years ago, I actually just wanted to write a little paper about how Kantians shouldn't feel guilty if they park for longer than 2 hours in those 2-hour parking spots. But unfortunately, I found out that paper required answers to much more foundational questions, and I've basically been laying the groundwork for it ever since. I still haven't gotten around to writing the parking paper. The paper I'm presenting today, though, I feel is getting close to the heart of my Kantian framework for ascertaining our legal obligations. It gets there by integrating 3 claims. The first of those is a claim about the structure of the Kantian concept of innate right. Kant characterizes innate right as the only original right belonging to everyone simply in virtue of their humanity. Innate right therefore differs from acquired rights, such as property or contractual expectations, which we acquire through our choices and which we can freely discard. Innate right is unalienable, but what does it consist of? According to Kant, it consists of freedom understood specifically as independence from constraint by the choice of any other person, to the extent that that independence can coexist with the equal independence of others. After Kant explains this much, he goes on to say something rather perplexing. He says that innate right, quote, already involves the following authorizations, which are not really distinct from it, as if they were members of the division of some higher concept of right. Innate equality, that is, independence from being bound by others to more than we can in turn bind them, a human being's quality of being his own master, as well as being a human beyond reproach, since before he performs any act affecting rights, he has done no wrong to anyone. And finally, his being authorized to do to others anything that does not in itself diminish what is theirs, such as merely communicating his thoughts to them, telling them or promising them something, etc. These 3 so-called authorizations can in substance be summarized as equality under law, independence, and association. But what kinds of legal incidents are these? It is with respect to answering this question that I've discovered that Hohfeld can help me. Innate right itself, independence from constraint, is a true Hohfeldian claim right to bodily autonomy that comes complete with a correlative duty not to violate the bodily autonomy of others. The authorizations of independence and association, I maintain, are best understood as domains of Hohfeldian liberty, potential actions that do not wrong others and are therefore shielded by our innate right. Equality under law, by contrast, is a Hohfeldian immunity, which is coupled with a correlative disability on the part of those who exercise lawmaking powers, disabling them from imposing legal obligations unequally. I hope that thinking about equality under law as a Hohfeldian immunity will yield some guidance concerning the severability of unconstitutional provisions from statutes in the context of, for example, United States law. but it has not done so for me yet. So today, I will be focusing on part 1 of my project, Independence and Association as Domains of Hohfeldian Liberty. Now, as I mentioned, my analysis integrates 3 claims, and my claim about the structure of innate right is only one of them. Claim number 2 is a claim about the nature of criminal wrongdoing, and I will gloss over the details now because we have limited time, and it is explained in much better detail in an older paper of mine called 2 Types of Legal Wrongdoing. Essentially, I argue that whilst a civilly wrong action is wrong in virtue of a feature of its physical manifestation, and that is its physical incompatibility with the freedom of others, a criminally wrong action is wrong in virtue of a feature of its maxim, its internal principle of action, specifically that the legality of actions on that maxim would be incompatible with universal external freedom. Claim number 3 is an account of legal obligation that I first proposed in a different previous paper called Juridical Law as a Categorical Imperative. To understand my account, it's important to understand that within a Kantian paradigm, there is a deep symmetry between external or juridical law on one hand and internal or ethical law on the other. In both cases, a law just is an unconditional rational requirement. In other words, a categorical imperative to do or refrain from doing X. Such a requirement is unconditional in a very specific sense. It is required of us regardless of our particular preferences or projects. Unconditional does not mean that particular legal obligations must hold in all circumstances. In fact, some do and some don't. Given the symmetry between internal and external law, the challenge for Kantian theorists is to explain how it could ever be the case that a statute passed by, for example, the UK Parliament could create a new categorical imperative for individuals. It seems implausible, right? The essence of my account is this. Positive law gets its initial normative grip on individuals by presenting them with an alternative between their own individual continued external freedom, understood as independence from constraint by the choice of others, and the loss of freedom. In other words, lawmakers create a new law by creating a situation in which individuals see themselves as free when they obey the terms of the statute. But they also apprehend that disobedience will result in the loss of their freedom. Most of the time, and we will discuss exceptions later, individuals can see themselves as free when they obey the terms of a statute, because the authority to make neutral rules of conduct is a prerequisite to our enjoyment of external freedom, to which we each have an innate right, and that we are rationally required to vindicate. For although we each have a right to equal freedom in a state of nature, we cannot actually have freedom itself, because there is no independent constraint on those who are stronger than we are that prevents them from violating our bodily autonomy. Our stronger neighbors might choose not to use violence against us, of course, but in that situation, we are dependent on their continued choice to respect our bodily integrity, and therefore are not truly free. Our independence from our neighbors, that is, our freedom, requires that our bodily autonomy be secured by externally enforceable laws. For Kant, the legislative authority just is the authority logically necessary to secure our independence from our neighbors. And so long as lawmakers act within the bounds of that authority, we can see ourselves as free under laws that we have, in effect, given ourselves for the purpose of securing our own external freedom. By contrast, a criminal punishment is traditionally exactly the sort of thing to which a person cannot rationally agree. In other words, it is a constraint on the bodily autonomy that is part and parcel of innate right. The line between that which is merely ours and can therefore be alienated and that which is actually juridically us and cannot be is already well policed by ordinary contract law doctrines. We cannot sell ourselves into slavery or indentured servitude because our bodily autonomy is part and parcel of our juridical agency itself and cannot be alienated. More conventional employment contracts cannot be specifically enforced for the same reason. This very feature of physical coercion is what enables external lawmakers to set up new categorical imperatives for us. A choice between one, obeying and seeing ourselves as free, and 2, disobeying and becoming liable for a punishment that is incompatible with our innate right, is not a matter to be resolved based on our personal preferences. There is exactly one thing that we are rationally required to do in that situation, which is to obey the law. This account of legal obligation tends to raise many questions, and I will deal with just 2 of them briefly now. First, some people worry that this account focuses myopically on the criminal law and ignores a lot of other laws that seem to create obligations for us. My answer is that the actual obligations that underwrite civil laws, doctrines such as tort and property, are indeed to be found in the criminal law, which makes intentional violations criminally punishable. If it were not the case, then it would be possible to pay cash for the right to violate the rights of others, and the rights of others would not be equally secure in the way that freedom understood as independence requires. To see how this works, notice that it is not criminal conduct to withhold a payment because of an honest disagreement about the terms of a contract. But once legal judgment is issued by a civil court clarifying those terms and ordering payment, a failure to pay what is owed amounts to criminal contempt of court, a full-blown violation of a Hohfeldian duty. Hohfeldian analysis can make sense of some other common examples, such as legal constraints imposed on administrative discretion of a public official. Such constraints are best understood as limits to the scope of the power that the official exercises in her role, rather than as Hohfeldian duties. So a nominally official act that exceeds the scope of an official's power is just a legal nullity. Of course, an intentional abuse of power that violates the rights of others is criminally punishable and does amount to a Hohfeldian duty. People also tend to worry that my account might be authoritarian, might make no room for appropriate civil disobedience. This is not really a worry about my account specifically, so much as it is a general worry about the Kantian idea of law as a categorical imperative. How can a legal theory be meaningfully liberal, which I maintain that Kant certainly is, if lawmakers can impose unconditional obligations on us? But not only is my account compatible with lawful civil disobedience, I believe it offers an exceptionally clear explanation of exactly how it works. Remember that in order to create a new law for us, lawmakers must establish 2 alternatives: obey and see ourselves as free under laws we give ourselves, or disobey and become liable to a punishment that is incompatible with our innate freedom. Both pieces have to be in place, or there is no one thing we are rationally required to do, and a fortiori, no law. Now consider a statute that prohibits the peaceful expression of a minority religious belief. Kant himself referred to an enactment of this kind as null and void, but why would that be the case? On my account, a statute like this one fails to be a law because it cannot set up an alternative between freedom and the loss of freedom. It cannot do so because it is conceptually incompatible with our freedom understood as independence, which lawmakers have the authority to constrain only for the purpose of securing the equal freedom of others. Now, to be clear, lawmakers are authorized to make definitive empirical determinations about how to ensure the security of the state, and sometimes lawmakers make foolish decisions about, for example, whether a particular tax or safety regulation is necessary. Laws that are conceptually compatible with equal freedom but reflect foolish empirical mistakes do obligate us because we need some independent authority to resolve contestable empirical questions about governance. However, no one can make any person embrace a logical contradiction. If a statute is incompatible with equal liberty in every possible world, as one prohibiting peaceful religious expression would be, then it cannot be a law because we cannot regard ourselves as free when we obey it. A statute like this one simply presents individuals with 2 qualitatively different types of oppression: religious suppression or imprisonment. Faced with such a choice, there is nothing in particular that an individual is rationally required to do, and she is entitled to pick her poison. If she provides for a family, she may opt to obey the statute. If she is especially devout or public-spirited, she may choose to disobey it, without thereby becoming justly punishable. With all my claims now out on the table, I will turn to my proof of concept in my paper, necessity as a defense in the criminal law. Recall that I have characterized innate right as a Hohfeldian right to bodily autonomy, and I have said that this is the only right we have even in the state of nature. For this reason, it is always wrong, that is, contrary to duty, to kill an innocent person, even if doing so is necessary to save one's own life. Kant discusses the famous case of the shipwrecked sailor who pushes an innocent person off a plank in order to save himself. The sailor is a murderer because he violated the innate right of his victim, but he is not punishable under the criminal law. Kant obliquely explains that such a law could not have the effect intended. If I am correct about how statutes create legal obligations, then the sailor is unpunishable because the external incentive provided by the relevant law, death at the time, could not create an unconditional rational requirement for an agent in a situation where a future of freedom under laws is not an available alternative. Because the natural law of innate right is still operative, its moral force alone could move the sailor, and should move the sailor not to kill the innocent. But if it does not do so, the positive law can have nothing further to contribute. Now, compare that situation to a much more controversial hypothetical: necessity in cases that do not involve physical violence, but instead involve only unauthorized uses of private property. One famous example involves a hiker who is caught in a blizzard and who breaks into an unoccupied hunting cabin in order to save himself. Arthur Ripstein supplied the dominant Kantian analysis of this hypothetical in an article titled In Extremis. On his account, this hypothetical must be understood in the same way as the one involving the shipwrecked sailor. The hiker is a wrongdoer, on this view, who escapes punishment only because the criminal law could not operate properly in his particular case. But this seems like a problem, because in Kant's normative philosophy, our legal obligations just are moral obligations. They are categorical imperatives, just like the ethical ones, and just as binding. Ripstein's analysis therefore leads to the overwhelmingly implausible conclusion that a freezing hiker has a moral duty to refrain from entering a cabin, even at the cost of his own life. Fortunately, my three claims about the nature of innate right, the nature of criminal wrongdoing, and prerequisites for legal obligation together lead to an equally rigorous analysis that yields what I believe is a more plausible conclusion. Recall that without a state, our independence stretches only as far as our fingertips, because any expansion of our independence to include rights in external objects, that is property, would require a universal set of rules for acquisition and an independent enforcement mechanism that would create the correlative legal duties, categorical imperatives, to respect those rights. Without a system of punishment, I maintain, we cannot have a system of property. While I have explained this in terms of categorical imperatives, the status of criminal punishment as a prerequisite to the creation of new legal obligations can be more intuitively understood in terms of equality under law. I cannot see myself as having a legal obligation unless I am assured that others in my jurisdiction are equally bound. My self-respect won't allow it. The specific way in which criminal sanctions provide equal assurance is by giving everyone a dispositive reason to obey the law, the preservation of their own external freedom. This does not mean that everyone will actually obey, of course, because human beings are often irrational. But the universal provision of a dispositive reason to respect the equal rights of others is the only kind of equal assurance that the state can possibly provide. If I am right about this much, if I'm correct that the metes and bounds of acquired rights like property are determined by the reach of the categorical imperative created by a threatened criminal sanction, then property rights cannot extend to preclude uses by others in circumstances of necessity. Because when life itself is at stake, criminal punishment cannot establish an alternative between freedom under laws on one hand and the loss of freedom on the other. Death will, among other things, involve a complete loss of external freedom, which is one half of the two-part mechanism by which the state can create new categorical imperatives for us. Without the freedom versus loss of freedom alternative in place, the state cannot provide us with a dispositive reason to respond to the sanction by obeying. And indeed, to obey by refraining from doing something that we would have the liberty to do in a state of nature, which is to seek shelter anywhere so long as we do not violate the innate right of others to bodily autonomy. In other words, the necessity defense does not reflect a Hohfeldian right on the part of the individual who seeks shelter, and thus there is no correlative legal duty of rescue. Instead, necessity in the context of unauthorized uses of property is a residual domain of Hohfeldian liberty that is shielded by our innate right, because no statute can do what it would actually take to remove those actions from that domain. Now, at this point, I could undertake to address a string of objections in the spirit of prophylaxis, but I think I would rather hear your thoughts. So I will leave it here from now, and I look forward to your questions and comments. Thank you.
Thank you.